Hello everybody. Hello. Oh, I'm glad. Oh, the notification. Okay. Just thought, yes, I sent it out. So I'm wondering if the notifications are working now. That's exciting. I hope so. Hello, welcome everybody. Welcome in. Happy Monday. Nashville, Tennessee. Love that. Love it. Good to see you. Welcome everybody. Hi, John. Good to see you. Yes, I'm so glad. Yay, notifications. Woohoo. Oh, I'm so glad to hear that. Yeah, I had been wondering about that. We'd been having some problems getting the notifications out recently. So I'm glad they came out from Missouri. Well, welcome, Veronica. Thanks for coming by. Oh, you got it too. Yeah, Mondays. Oh, I know, right? Oh my gosh, there's another very fun creator, and she's had a manic Monday, and I feel pretty bad for her. Hopefully, she'll be able to swing by tonight so we can cheer her up a little bit. But yes, yes, I do have a few things just to say to kind of clarify on Ohio, but I've got several orders and motions that have come out from the other cases too. So hello, Deborah. Hello, Hitch. Good to see you. Welcome. I'm just getting started. So do you cover updates on Trump? Absolutely. Yes, I do. I do all of those for sure. Yeah, I still haven't heard about Colorado yet. I've not heard anything. So I'm keeping my eyes peeled, but Minnesota, we heard back from them, but we've not heard from Colorado as of yet. And then Michigan just got started. Now, there are probably maybe a dozen or 14 other states that have cases filed, but they're all kind of like pro se cases and they're not very strong. So we haven't seen them yet. Did you get a new computer? No, I didn't. Oh my goodness, my computer is so mad at me. Oh my gosh. It's so mad. No, it's green. It's green. It's got a little box sometimes, though, that moves around. As long as the box doesn't cover what I'm reading, I'm okay. How's my hand? My hand's doing okay. It's doing okay. The swelling's going down. I tried to get my biggest ring on at least, so I was feeling a little uncomfortable not having any rings. So I do have, but it'll be a couple more days, I think, before the swelling. Can we review the Murdaugh case? Sure, from start to finish. Yeah. We had, a motion for a new trial that's come in. It's not been set yet for a hearing, to my knowledge, but that's such a fascinating case. Here in Minnesota, they said it was too early, can file again. Exactly, Leslie. Yep, and that makes sense with how the Minnesota law is written regarding the primary stuff. So that's okay. Standing at 5 foot. Okay. So, Kristen, here's what I found out today. All right. So I talked to for anyone who's new, I had an incident and it resulted in my hand getting a little bit messed up. So I had talked to, well, hello, Frank. Hello. I spoke with my doctor and I said, hey, it's not really in my nature to just be, punchy. And so, what's going on? So she actually said that there's a medication that I'm taking that's one of the side effects. And I said, the side effects is punching things? And she's like, well, you can have really bad night terrors or that will, kind of mess up the situation. And I said, well, that wasn't listed as one of the side effects. But anyway, so I'm off of that medication. I am not kidding you, everybody. It was a medication. And then she said, if that doesn't work, let me know in a week because there's a second one that you're taking. Oh, my goodness. So I don't know. I'm not sure how I feel about that. I was like, can't we just go off of both of them right now? I'm feeling a little worried. So we'll see what happens. But I didn't know that could be a side effect from medication. Oh my gosh. No, no, I was my computer. Oh, yes, you got to be careful. But it was completely, I mean, I felt bad. I'm like, this really doesn't fit. I'm not really a punchy person. I can get stabby if I need to, but I'm not really a puncher. Oh my goodness. So we did get some, we got behind, well, now Kristen, now come on. I can't. Oh my goodness. Oh my goodness. No, Hitch. No, none of that. None of that. No. I was just having a bad dream and I woke up and everything on a table next to me was on the floor and my hand was all giant. And I was like, well, that's weird. So we got to take it care of. Apparently I can defend myself if I need to. Oh my gosh. So yeah, I had no idea. So make sure you read those side effects. I really, well, and I'm concerned because she said there's two. She's only told me to stop one. So throat punching. Yeah, he's been ducking a lot lately. He's been kind of kind of leaving rooms quickly. Yes, I had to move everything away. I moved everything away, so I had a big big area with nothing in it. So oh my goodness. Yes, I don't know what's going to happen. So everybody just hope for the best for me and my my side effects. Apparently it can happen to some people, so you got to really read those side effects. But welcome in, everybody. Welcome. Good to see you. Happy Monday. We will on TikTok. No, I didn't, Hitch. I never thought I would be sharing it with people live. But you all have been with me through all of the adventures, so I had to come up and give an explanation. He has a helmet. Oh my goodness. It's a lot of problem. It's a big problem. It's a problem. Just got the notification. Oh, good. I'm glad. Yeah, I heard that notifications were working a bit better. Break someone's nose. Oh, yikes. Yeah. I have a, well, last night it helped. I wore a sling to bed, so I think that helped. So one of my arms was bound, so I couldn't get my dominant hand out to punch anything. So it worked out. Okay, we could do an interview sometime. That'd be funny. Yeah, a little bit of both. Am I coughing or laughing? It's a little bit of both. It's a mix. Straight jacket. Oh no, Sheila, no. Okay, well, some of the notifications are working, some are still not working. We'll keep working on it. No, oh, well, we'll get there. We'll get there eventually. At some point, we'll get there. So welcome in, everybody. Welcome. I've got lots of fun stuff for us tonight. Oh my goodness. So I have, out of the New York case, we know Don Jr. testified today for the defense side. And so I've got a letter here set out by the AG asking for some of the defense experts to not be used in court. So it's just about 2 or 3 pages. So I'll go through that. And then I have the defense list of witnesses. So they've got 12 witnesses that they are planning to call. So we've got that. Worried about your dreams? Yes, you should. Be careful, everybody. Be careful. Don't put anything next to you. You never know what happens. Oh my goodness. Live and learn. All right. And then out of Florida, I'm a little slow moving here. Okay. So now out of Florida, we have an unopposed motion. This is the first unopposed motion I've seen. The discovery motion was supposed to have been a joint motion, but that didn't really happen. But we have an unopposed motion here in the Florida case. So I'll be going through that, just giving you a preview here. And then we've got in the District of Columbia case, we have an opposed motion for extension of time by Mr. Trump. And then we've got the government's opposition motion, and then we have an order. So these are all the DC updates there. So I've got a few forms to do updates here. And then I also wanted to talk about this issue that's going on in Ohio as well. So lots of fun stuff for tonight, everybody. Lots and lots. So I will go ahead and get started. Let's just start right out with the Ohio issue that's been going on, so we can just kind of get this sorted out. I had put up a couple of posts earlier today, kind of trying to explain a little bit about what had been going on. I'm sure most of you have heard there's a rumor going around about the issue 1. So let's take a look at issue 1 here. My writing is limited tonight, everybody, so my sticky notes are just not going to work. My fingers are too swollen, so I will try to just remind everybody what it is. But Ohio. But I will, we should be okay. They're only a couple pages long, each thing that I've got for tonight. So, but let's take a look here at issue 1 that was passed in Ohio. Both of your vids. Yes. Cost in ink and paper. Well, I think it's just a wonderful investment, and I've got lovely supporters here who have helped me so much. So, ink and paper, definitely. Lots of recycling going on too. So the people at the recycling place kind of don't even look at me anymore. They're just like, all right. So here we go, everybody. Issue 1 out of Ohio. Let me grab my longer pen. It passed. We're good. I know the Republicans want to try to find a way and take the freedoms. Yes. So I had a few people ask if I could just explain the language. So I thought I'd just take a little bit and talk about that. And then also the press release that came out. I won't spend too much time on this, but I think it's worth going through. I thought the language was very well done. So I thought it would be helpful. So here we go. We have issue 1, a self-executing amendment relating to abortion and other reproductive decisions. Proposed constitutional amendment proposed by initiative petition. So this is a citizens initiative. So in Ohio, there are several ways that you can amend the Constitution. And it can go through the General Assembly, or it can go through citizens initiative. And that's what they did here. Actually, let me just show you. So you don't have to take my word for it. Here we go. Let me show you here. Sorry. I miss my other hand. I really do. So we can have an initiated constitutional amendment here, an initiated statute or referendum. So there are multiple different ways that you can add laws in Ohio. And so what we've got for issue 1 was the citizens initiative. So that's prescribed by law. Oh, Jennifer, that's so sweet of you to say. Yeah, oh yeah, come on over. We're calm over here. I think the more you know, the calmer you feel at some point, hopefully. Who actually writes these amendments, like deciding the specific words? Hey, great question. And actually, it comes about, let me show you here. Let me see. There is a board, actually, that approves it. So the petition's done, the language is drafted. So, and then we've got initiative and referendums to enact laws. So under this section of the code, they put in that the language goes to a board, and then the board takes care of it. So laws proposed by initiative petitions first to be submitted to the General Assembly. Ballots shall be so printed as to permit an affirmative or negative vote upon each measure submitted to the electors. Any proposed law or amendment to the Constitution submitted to the electors as provided in section 1A and 1B, if approved by the majority of the electors voting thereon, shall take effect 30 days after the election. So it's all set out in here, which I think is great. Now, usually what happens when they work on laws in the legislature, whoever proposes the bill will kind of put the language together, but most representatives don't know how to actually write statutory language, and that's fine. So they'll have like a legislative processing office. And so you kind of write in what it is that you want the law to say, where you want it to go, what you want it to mean, and then they tweak it and make sure that all of the language is correct. And it's usually an office of attorneys and paralegals that are trained in how to write statutory law. So there's a lot of that going on. That's how normal, regular situations go on. But when it comes to amendments, it still has to go through a proper process in order to even get put on the ballot. So the language has to be pre-approved before it's on the ballot. And actually, I've been reading through here, and it's interesting. Here, there's an Ohio ballot board that's involved. So, also involved. So it seems like here that there are a lot of checks in place for the language itself. One thing I found very interesting was it says no law or amendment to the Constitution submitted to the electors by initiative and supplementary petition and receiving an affirmative majority of the votes cast thereon shall be held unconstitutional or void on account of insufficiency of the petitions by which such submission of the same was procured, nor shall the rejection of any law submitted by referendum petition be held invalid for such insufficiency. So, one of the things that that group of, I think there are four Republicans in Ohio saying is that it wasn't written correctly, but the language was pre-approved before it even went on the ballot. So everything was set. Everything was set before it even went to the ballot. Oh, board. No, not a lord. Oh, my goodness. Ohio's a little different, but they're not quite that different. Oh, my gosh. Yes, that stops them. The Constitution itself, everybody, is what stops them. So, the language here, let's just take a look again. Let's look back at the law. So Article 2 of the Ohio Constitution, Section 1, initiative and referendum to amend the Constitution. So this is the constitutional language. So the first aforestated power reserved by the people is designated the initiative, and the signatures of 10% of the electors shall be required upon a petition to propose an amendment to the Constitution. When a petition signed by the aforesaid required numbers of electors shall have been filed with the Secretary of State and verified as herein provided, proposing an amendment to the Constitution, the full text of which shall be sent forth in such petition. The Secretary of State shall submit for approval or rejection of the electors the proposed amendment in the manner hereinafter provided at the next succeeding regular or general election. So that's what happened. It was an off year, so it wasn't a general election, but it was just a regular off year. In any year occurring subsequent to 125 days after the filing of such petition, the initiative petitions above described shall have been printed across the top thereof, amendment to the Constitution proposed by initiative petition to be submitted directly to the electors. So we have all of these pieces that were submitted. So all of the pieces were done. Walking around getting signatures, really? So you've been involved since the beginning then, or you've been hearing about it. Yes, there's a policy, there's a procedure that you have to follow. And as long as those policies and procedures have been followed, you're good to go. So here's the language. So to enact Section 22 of Article 1 of the Constitution. So let's take a peek real quick of what Article 1 is, because each state constitution is different than our federal constitution. So in Ohio, they have their Bill of Rights is under Article 1. So when they set out their Bill of Rights, they're amending Section 22. So let's take a look quick at that. Go through Section 22. Here we go. Here we go. Oops. Hold on. I've got to flip my pages around a little bit. Hold on. Whoops. Okay. Also, I found this really great website that also explains the entire process. And this is on the Secretary of State's website. And it's nice because it writes out exactly what's required in order for it to be on the ballot, and then which section of the code is required as well. So I thought that was very helpful too. All right, I'm flipping. My flipping is not the best. Just a minute. Oh my goodness. Okay, so like I was saying, we've got the first article that sets out their Bill of Rights. So here's this. Now we've got Bill of Rights. Oh, there we go. Oh, my fingers aren't quite working right. All right, here's the Bill of Rights. So they're set out: inalienable right, trial by jury, involuntary servitude, the right to assemble, writ of habeas corpus, trial of crimes. So a lot of it's reflective of the federal constitution, rights of victims of crimes, but then a lot more is included: freedom of speech, freedom of the press, eminent domain, damages for wrongful death. Now, the part that's being added to here, right here, is to enact Section 22 of Article 1. So the last section that was added is Section 21, preservation of freedom to choose healthcare and healthcare coverage. So this is 21. So Section 22 will be added as the next piece. So that's where it will go. Did you see Jenna Ellis's testimony? Yeah, I saw that. ABC News, it looked like, had her proffer. And I think some of Sidney Powell's too. I did see a peek of that. I'll be taking a closer look at it, but it is really very interesting. So this is where 22 will go. So this language here, the proposed amendment, then would be added onto it. So the proposed amendment would establish in the Constitution of the State of Ohio an individual right to one's own reproductive medical treatment, including but not limited to abortion. Create legal protections for any person or entity that assists a person with receiving reproductive medical treatment, including but not limited to an abortion. Prohibit the state from directly or indirectly burdening, penalizing, or prohibiting abortion before an unborn child is determined to be viable, unless the state demonstrates that it's using the least restrictive means. Grant a pregnant woman's treating physician the authority to determine on a case-by-case basis whether an unborn child is viable. Only allow the state to prohibit an abortion after an unborn child is determined to be is determined by a pregnant woman's treating physician to be viable, and only if the physician does not consider the abortion necessary to protect the pregnant woman's life and health, and always allow an unborn child to be aborted at any stage of the pregnancy, regardless of viability, if the treating physician's determination the abortion is necessary to protect the pregnant woman's life or health. So, if passed, it would be effective 30 days after it. Shall the amendment be approved, yes or no? So this was approved. All of these pieces were approved. It's an addition. Yes, it's an addition. So it will be Section 22 added to Article 1 of your Constitution once it's all put together. So the question that keeps coming up is from this group of legislators here. There's, I think I'd read 4. Like, I'm not that up on Ohio politics, but here's what they put out. They put this press release out here. So our legislators will be introducing several bills to address this issue in the coming weeks. Like, that's fine. They can put whatever they want in front of the legislature. I mean, there's all kinds of people that's doing that all the time. In fact, there was a state legislature recently who tried to make a law putting limits on congressional senators at the federal level for their state. So they tried to put term limits in place through their state house. So the state voted for it, the governor signed it, and it said that senators could only serve a couple of terms to the U.S. Senate. That was deemed unconstitutional. So they actually went through, wrote the law, passed the law, signed the law, but it was unconstitutional. So these kinds of things happen quite a bit, especially these last couple of years, I've noticed. Last year in particular seemed to have a lot of legislation passed and even signed by governors that was completely unconstitutional. So just keep that in mind. One of them is the Speaker of the House. Yeah, well, that's interesting. Yeah, so, yeah, I mean, again, they can propose whatever they want, but it doesn't make it, allowable. So foreign billionaires don't get to make Ohio laws, and, that doesn't even make sense. Pointing to millions from billionaires outside of America that helped fund issue 1. Again, that doesn't make any sense. It's a foreign election interference. Now, if anyone remembers, according to the Mueller report, let's see if I can, Mueller report. If you want to know what foreign election interference is, you can take a look at that 900-page report. And it will not stand. So nothing like that's occurring here. How do they combat this? Well, I think it's just knowledge. I think you just have to know that this is just a lot of bologna sandwiches. They arrest people for soliciting public officials to break their own oaths. They really do, David. That's a true story. They do. If you ask a public official to break their own oath, yeah, you could get charged. You could get charged. Issue 1 doesn't repeal a single Ohio law. In fact, it doesn't even mention one. So the thing about the new constitutional amendment, once it's in place, it means any law that's in conflict with it can be challenged. It does take a while to get all of the challenges through the court system, but that's just a process issue. If you add a brand new amendment to a constitution and it's doing away with what had already been done there, it takes a while to kind of clean up the books after that. What's the process to make an amendment for term limits in the Senate? It has to be done at the federal level. We would have to amend the U.S. Constitution in order for that to happen, because there's no age limit or time limit on justices, and there's no term limit set for Congress. We did pass an amendment setting term limits for the president, so it's possible to do that. I believe it's the 25th Amendment. And it's possible to do that, but we would have to have an amendment in order to pass that. Maybe spam. Well, either way. Okay, so, right. So there is a process, and it's going to take a while to clean the books up, but that's how it works for all laws. That's how all law works. The amendment's language is dangerously vague and unconstrained, can be weaponized to attack parental rights and defend these kinds of people. And that's just incorrect. That is just a blatantly false statement. This person then said, we'll continue to be a voice for every child in their mother's womb who cannot speak for themselves, which is fine. But that asks the question here, the ultimate question that we always have to ask is, does the mother's constitutional rights outweigh an unborn situation's rights? I'm not a scientist, forgive me, I won't say the right term. So, there's this idea here that we have an individual with constitutional rights, and then we have not someone with constitutional rights. And so that's that ultimate question. Can you slide the paper to the left? Yes. There we go. I'm glad you told me, Mads. Thank you. Right. Yes. So, and I understand, I am not a scientist, everybody, and I'm not a doctor. So I am not going to use the proper terminology because I just don't know it. I probably should. That's my bad. But, I think it's important to remember that there is some science involved here. So we have a person who was given constitutional rights. Juveniles were given almost all constitutional rights, but that didn't happen until the 60s. So, now it's like, what are we talking about? I can see your post, Deborah. I can see you. All right. So, if you want to keep advocating, go for it. But that doesn't mean that the amendment can be deemed unconstitutional. This person said, no amendment can overturn the God-given rights with which we are born. Now, I guess, this is troublesome, of course, because we have First Amendment, right? We can't have a particular religion established. That would be a violation of the Establishment Clause under the First Amendment. So 1 to 8 weeks is an embryo. 8 weeks returns a fetus. Thank you kindly, Daisy. I appreciate that. I know that there are specific terms, so I just don't remember what they are. Right. Well, I mean, I'm a JD, but I'm not a science doctor. And we cannot escape the fact that this is a science and medicine issue. So we can't. It's just what it is. But here, we of course can't. This is not this idea of natural rights that Scalia decided to set out in the Heller case is still not something that's going to be applicable. Ohio Republicans need to chill. I agree, Tiffany. I agree. To prevent mischief by pro-abortion courts with issue 1, I would not call Ohio courts pro-abortion courts. I would not do that. That doesn't seem accurate at all whatsoever. Ohio legislators will consider removing jurisdiction from the judiciary over this ambiguous ballot initiative. So this is the part that's really frustrating for me to hear, because they're talking about removing jurisdiction of the courts. And I think that's why so many people are completely overwhelmed, because they're like, oh my gosh, they make the law so they can take away the jurisdiction of the court. But that's just not true. The jurisdiction is set out in the Constitution. So the Constitution in Ohio sets out exactly what jurisdiction does the Supreme Court, what jurisdiction does the appellate court have. All of those things are set out in the Constitution. So this isn't stuff that can be just changed by passing a bill. This is constitutional law. So if you want to change the jurisdiction of the courts in Ohio, you would have to amend the Constitution. You would have to change the Constitution. So this question again, that the courts, their jurisdiction can be changed or whatever, is not possible unless you change the Constitution. And we already saw how difficult it was to change it to begin with, much less changing the basic structure of the courts. So, and some of these go all the way back to the 1800s. So 1850 is when the Supreme Court was set out. 1868 set out the organization for the Court of Appeals. Where does the rubber meet the road? You'll have to be... I'm not sure exactly what you mean by that. I mean, do you mean... I can't stand it. The bottom line is I can't imagine anyone... Yeah, I don't think anyone is necessarily pro that. I mean, I think we're all pro health. So, okay. So let me break it down. Is it too much lawyer speak? Is that what I'm doing? It's the woman's right to decide for her body. Well, according to the amendment that's being passed, no one in the House of Representatives can take the jurisdiction away from the courts. And the language of the amendment, everything was done properly, and so it can't be overruled. So that's it. That's where the court rejecting the jurisdiction. Right. So the process, again, anytime a new amendment is proposed, anytime a new law is changed, is that it'll take time. So let me give you an example. There is I'm trying to remember which is the most controversial in Ohio. I think there's a law regarding a certain notice. Is that right? Is there a notice law there? Is there yeah. This is just posturing. Yes. So let's just say, let me give you an example. So let's say right now on the books, let me just give you the heartbeat bill. How long is that one? Is it 6 weeks? So let me give you an example, okay? This is just an example. All right. So let's say, you need to be more specific. Yeah, I know. Oh, this is a tough one. Let's just say there's a 6-week heartbeat. So if there's a heartbeat, then there's no ability to obtain an abortion. No abortion, okay? After 6 weeks, once there's a heartbeat. That's the law in Ohio, hypothetically, okay? So this amendment is proposed, it's passed, and in 30 days it passes. So someone comes in and they're at 7 weeks and the doctor is saying, this is a medical emergency situation. Again, I'm just making up a set of facts here. And, in the interest of the mother's health, we have to terminate the pregnancy. The mother's, sick or whatever. So according to the 6-week heartbeat bill, that would be illegal in Ohio. But now that the amendment is in effect, this law is not in play anymore. All right. Now, what happens is if a doctor says, well, I refuse to do it because under the law it says 6 weeks, then that doctor would be sued and the issue would be taken up. Now, that would be the worst case scenario. The best case scenario is that you're going to have groups of people picking apart all of the different abortion laws in Ohio, and there are some pretty serious ones that have been there for a long time. And they're going to be bringing suits, much like Roe, where she was no longer even pregnant at the time she brought the suit because of the time that it took for all of these things to happen. So you don't even have to have a pregnant mom in that particular situation. So what I'm trying to say here is that it will be a case by case where each situation, the Constitution will invalidate prior laws that conflict with it. But if there are people trying to still enforce that law, they will get sued. Does that make sense, everybody? Voted to not change it and make it part of the Constitution. Okay, good enough. Yeah, okay, good. Yeah, it just takes time. So the laws, they're saying any of the laws that are in place right now that have been put into place that are in conflict with the Constitution will win out. So any lawsuits that are brought claiming that the laws are on the books that are in conflict, those will be hashed out in the courts. It'll take a while, but the effect of the amendment will be right away. Did I get it? Oh yeah. Oh my gosh. I'm sorry, everybody. Heartbeat was triggering. I'm sorry. No. I'm trying to not be. I'm not a scientist. I'm sorry. Okay. The bottom line is the Republicans are full of spam sandwiches. Okay. This is an attempt to freak everybody out. So they lost and they're saying, well, we're not going to accept this language. We're not going to accept what everybody agreed to. We're going to do whatever we want to do. But according to their Constitution, they can't. So that's the bottom line. Did we get there? Oh, hopefully we're close enough. Yes. I tell you, everybody, I know this is a tough issue. This issue is so tough. And, I've spent decades looking into and following Roe because honestly, the first time I heard about the Casey versus Planned Parenthood case, and I realized that the Casey case took about 85% of Roe away. So Roe only had a tiny bit left to it after the Casey case. So I've been watching these cases for a long time. So when I think of what we're talking about, I think in terms of trimesters, because legally that's how it was originally defined. But what I'm trying to say here, what was Casey? Casey versus Planned Parenthood. Yes, that was a dark day. That was a dark day, everybody. Casey v. Planned Parenthood was the case that completely gutted Roe. And I think a lot of people don't realize that. And it was decided in 1992. So in the Casey case, we had Roe versus Wade, and it set out different standards depending on which trimester, the first, the second, and the third. First trimester, mom had the most interest. Second trimester, mom and the government had an equal interest. We needed to assess it. Third trimester, government had a bigger interest. That's how they defined who had the most interest and how the rights were to be set out and how the laws could be regulated. In Casey, they took away the strict standard and they put in that in certain situations, the government's rights will prevail. So sometimes in a first trimester and sometimes in a second trimester, the government's needs will go ahead of the mother's, depending on what's going on. Yes, the government has an interest. Yes. So, that's a very rudimentary way of explaining it, but that's what happened in Roe. And when Roe split the question into 3 trimesters, they created a standard that didn't work properly because it didn't work with science. And that was one of the biggest issues in the Casey case, was we had this question involving science. And when science and the law meet, we've got all kinds of problems. It's so unbelievable, but nobody paid attention. Yeah, exactly. So for me, when I learned about the Casey case, that's when I grieved for Roe. That's when I recognized that Roe was done, because there wasn't much left. There was just a little bit left of Roe, and all it would take would be the overturning of Casey, and even the smallest amount of rights left to pregnant mothers would be gone. And that's what happened with Dobbs. And that's just the legal history, and most people just don't know that, and that's fine. Does Dobbs take away the legal basis for HIPAA? No, HIPAA is separate. HIPAA is a different animal. You still have those kinds of rights. I miss the days of discussing penumbras of the rights of privacy. I do too, David. I do too. And that was the other issue, because both Casey and Roe talked about that right to privacy under the Ninth Amendment. All right. So, but then the Dobbs case, Justice Alito said there is no Ninth Amendment for abortion. So that's why Roe and Casey were overruled. Roe was dead the day RGB died. Well, and there's some truth to that, but many of us, again, viewed the Casey case as the beginning of the end of Roe. There really was not much left. So from the time that Roe was decided until 1992, that was when Roe was in full effect. But it never came back after the Casey case. The restrictions were always incredibly restrictive after Casey. That's why the Dobbs case came up, because a law was passed that was so extremely restrictive. And they said, well, even Casey allowed for a little bit. And so the Supreme Court said, nope, we're tossing both Casey and Roe. No Ninth Amendment right. This is a terrible, terrible visual aid. Sorry, everybody. So that's it. That is how that mess occurred. I miss Archie. I know. Yes, she was amazing. She was an amazing justice. There were many justices who were amazing. But, we've just had a really, really long history of this kind of a debate back and forth. And even when the court decided Roe versus Wade at the time, and you can listen to oral arguments online, actually, the court, when they're speaking, they don't understand the science either. They don't understand. Yes. Hopefully that's helped clarify things a little bit. Again, I am not a scientist, everybody. I'm not, but I am definitely absolutely for medical treatment and appropriate medical care for everybody. All right. So, why isn't the science required? It should be. In my opinion, in my humble opinion. Thank you. Had to leave and come back in. Oh no. All right, everybody. So hopefully that answers everyone's questions about the Ohio situation. So when you start hearing people talking about the Ohio situation, or someone tags you, you know what's going on now. Had some freezing left and came back. Okay. Most frustrating part's that they don't know, but they think they have the right to decide. It is very frustrating. It is frustrating when you have people who are not trained or do not understand the medical profession making decisions about the medical profession. I mean, it is. It's very frustrating. Did you see my comment on Iowa law? No, I didn't. Swing back around. I'll watch for it. Gonna name my new band The Ohio Situation. Oh my goodness. Oh my goodness. Will do. Okay, yeah, swing it back around. I get it. And they're like, if it's a woman's body, I understand. And there's a lot of, triggering things going on. But the real issue here is a medical issue. And I don't care if you're a man or a woman, but if you have medical knowledge of what is actually, harmful for a pregnant woman, I think that's an essential piece of the knowledge needed here. You blinded me with science. No! Dobbs weakens HIPAA. Well, I think HIPAA I think it left the door open. So I would say that's accurate. what month it would be legal to get in Ohio. Now that I don't know, that I do not know. That will have to be set out state by state. State by state. Medical has no reason to be in law. It's a good, yeah. I mean, it's hard. I missed this. We were unable to do anything about them overturning. Are we unable? No, there's no overturning. There's no overturning, CC. I'm so glad you asked. There's no overturning. This is just a lot of hot air. This is a lot of posturing and completely false information. This is the same as them saying the election was false. All right, it's the same thing. So instead of saying the election was false, they're saying the amendment can't pass. It's the same thing with just different words. Yep. Just need one good run to codify. Exactly, Johnny. Yeah, exactly. They can only do away with it with another amendment. Exactly. You got it. You got it. Can they be charged for false claims? No, they can't, because they can say whatever they want. They can go out and say whatever they want as long as we don't have defamation. But they can go out and say, hey, Rudolph the Red-Nosed Reindeer is now in charge of the government in Ohio. They can say that if they want, even though people are like, what? They can say it, but the pregnancy is viable. So all of the details, those that you will have to check, and they will have things set out the way that they need to be. Debate and speech clause, yes. Glitching like Mitch. Oh my gosh, Rudolph would be better. Oh my goodness. So the existing abortion laws don't go away unless removed by Congress or challenging the court. Do you mean the state laws? Because we don't have any. We have a executive order in place federally that has some protections, but you only need 2/3 of a majority to add amendment, plus the states have to sign on it. Yeah, exactly. And, we can't keep the lights on in Congress, as I've been saying, so I don't think we're going to have an amendment anytime soon. No, it's not vague. No. It's fine. It was approved. There's a whole process on what the language has to be like, and all of that has to be approved before it even gets sent to the, before it gets put on the ballot. So it's all scare tactics, everybody. It's all just claiming again that the election was bad. So yeah, but I can see how it can be very, very frustrating. No law should be in the medical profession, but it's regulated by statutes to some degree. True. And, all kinds of things are regulated to some degree. And that's why, we've got medical malpractice requirements. We have insurance practice. We've got all kinds of other things. But when it comes to specific procedures, I think it's really interesting to see how specific medical procedures are codified in different laws, right? So let me ask this. If someone's having heart failure, when their heart failure is occurring, is that in the state code? Is how to treat that heart failure occurring in the state code? So, or a lung transplant there's transplant rules regarding how things get from A to B and permission, but the procedure itself. So you have to kind of ask those kinds of questions. What other medical procedures are there in the state law that are this specifically set out to take away decisions from doctors? That's really the issue, in my legal opinion. Usually the minute seems pretty clear. Right. Again, medical law. Yeah. This is about doctors doing their best treatment for their patients, and that's what they're required to do, right? So, yeah. Well, you have to wait for. Well, yeah, exactly. I'm just curious. What laws out there do talk about what medical procedures you can have? I think it's very interesting. So. First, do no harm. Absolutely. Must be written by medical professionals. Well, in my understanding was this amendment, all of this was put together by doctors in Ohio and nurse practitioners and the medical field. They were the ones putting this together. That was my understanding. Medical practice is regulated. True. Evidence-based practice, yes. People signing their, yes. Yeah, it can be difficult. Yes. Now, Terror Bear, I think that's a great example. A lot of the trans laws with medical treatment elements are being challenged because of that very issue as well, right? Because a doctor is making determinations and their hands are being tied, or they're not being allowed to treat their patients in the way that's best for their patients. So we have a lot of those kinds of same issues going on. Last is called a doctor, true. People start to be cloned. Oh my gosh, we can't talk about the cloning, everybody. We can't, nope, I'm triggered, everybody. Nope, sorry, we gotta move on. I can't, I need a moment. I can't. No, cloning, please. I can't. Well, that's a great question for pregnant children. I don't know. That's a great question. It bothers me. It bothers me, everybody. I will tell you that right now. It's a trigger for me. The cloning is a trigger. Okay, tea break. Oh my goodness. Well, here's the deal. As many of you probably already realized, my partner, my partner in crime is a scientist, and his doctorate is in genetics. And there was a lot of cloning involved, and I've never recovered, okay? I've never truly recovered, so that's why it's a hot button issue for me. Oh my goodness. Yeah. I mean, until you see your significant other getting up at 3:00 in the morning to go clone something, it can, it has a little, it's too soon. It's too soon. Oh my gosh. No. We made an agreement before we got married. I said, you can't come home glowing from. Okay. All right. Here we go. We got to move on. I'm seriously about the cloning. Yikes. No, Dolly. Oh my gosh. We could use more. No. His area was mice. That's how science fiction. True. It's true. It was very scary. It was a scary situation. I don't understand it. Code of ethics for the Supreme Court. Now, yes, that's fascinating. Just came out today, everybody. The U.S. Supreme Court has agreed to a code of ethics. And there are a lot of questions about that, right? Because they're saying, the only people that they're accountable to are each other. But that's kind of how it is in the legal profession. Like, we are a self-governing profession and we monitor ourselves. And so for the Supreme Court to come out with a code of ethics and then say, we're the ones that are going to enforce it, that to me makes sense. So I will absolutely be doing something going into their code of ethics. I will be very interested to see how similar it is to the federal judge's code of ethics. Should be voted on. Well, I'm wondering if it's just a similar piece to, the honor system, David. Yes. With more laughy emojis, but the honor system is how we work. Code of ethics. Who remembers Dolly? Yes. Oh my gosh. Seriously, I can't. Let's look at Trump indictment instead of something controversial. I know. Yeah, I mean, come on. Let's talk about Trump rather than cloning. Oh my goodness. Oh my gosh. No science lab in the basement. Yikes. Yes. Well, I will do a live on it, actually. Once that gets sorted out. Absolutely. Spend some time on that. Oh my goodness. All right, everybody. Seriously, I'm going to have nightmares. We don't need that. I'm down to one computer. I've got to be careful. Isn't glowing green part of the fun? No. No, that was in the, that was in the prenup. We had an agreement. All right. Here we go. We've got focusing. We've got out of the Florida case. Oh my gosh. All right. We've got President Trump's. Again, you know that it's by Trump. This is Trump filing it. If it says President Trump on it, that's in a prenup. Yep. unopposed motion to reschedule hearing on SIPA Section 4 motions. So let's take a look here and see. I don't. We just sometimes this live gets away from me, everybody. All right. President Donald J. Trump submits the unopposed motion respectfully requesting that the court adjourn the February 15th and 16th hearing on the SIPA Section 4 motions due to a conflicting hearing in the Manhattan Supreme Court, People versus Trump. So this is scheduled for February 15th at 10 a.m. So let's look at this footnote here. Attorneys for President Trump conferred with special counsel's office, and on November 12th, the office confirmed it does not oppose adjourning the hearing to a date convenient for the court. In addition, defendants Walt Nada and Carlos de Oliveira do not oppose this motion. So let's take a look at the calendar, everybody. Calendar time. Here we go. I'm trying to quickly move on. Here we go. I'm moving on to the calendar. All right, let's see what we've got. So they said here February 15th and 16th. So we've got the section. This was just set out by the court. All right. So this was part of her new order where she kind of granted in part and denied in part. So she kept the trial date the same, but switched her hearings. So if you remember that. So this was a new setting of hearings that she had set out for Section 4. So they're asking then that those hearings be moved because People v. Trump then, the New York case, is scheduled for the 15th. So this, of course, I'm going to put on our schedule here. New York case, this is going to be the criminal case. All right, so we've got the criminal case that is being set, the New York criminal trial that's set for the 25th, but now we've got apparently something, according to this motion, now set for the 15th of February. His attorney filed the motion to extend the date in New York. I wouldn't doubt it. That seems to kind of be the theme here. So let's walk through and see what he's talking about. On November 10th, the court issued an order scheduling a hearing on SIPA 4 motions for February 14th and 15th and 16th. As your honor is aware, on April 4th, President Trump was indicted, arraigned in New York County on a 34-count indictment, charging him with falsifying business records in the first degree in violation of New York law. Here, also known as the hush money case, everybody, on July 5th, the Honorable Judge Merchan, assigned a Supreme Court judge, scheduled a hearing on the now fully briefed omnibus motions for February 15th. All right, so we've got omnibus motions. Judge Merchan ordered President Trump and his counsel to appear either virtually or in person at this hearing. Although President Trump's schedule could change, we anticipate President Trump will be present in person for the February 15th hearing in New York. All right, so we've got a briefed omnibus. Okay, omnibus. Oh, here we go. Come on, fingers. Omnibus hearing. Oh, all right. So that's what's scheduled in the New York case. So he's asking then to move the other cases. So I think that makes sense. He's going to start having some pretty significant conflicts. President Trump and counsel recognize the challenges associated with scheduling a 2-day hearing given the court's busy calendar and the conflicting dates of counsel and President Trump. Because President Trump's presence with counsel at the previously scheduled New York hearing is required, as well as the significance of both the New York hearing and the SIPA Section 4 hearing, we respectfully request the court adjourn the SIPA 4 hearing to dates that are convenient for the court, either earlier in the week of February 12th or the prior week. Well, that's nice that they actually set out a couple of dates that might work. This will allow both President Trump and counsel to be present and participate in both hearings. Okay, well, that makes sense. Counsel is available at the court's direction if further information is required, if they have any questions regarding the relief requested. So this is the most normal motion I've seen yet. It's taken 216 documents. We've gotten to a normal motion filed by defense counsel. Well done, defense counsel. Oh my goodness. Oh, yikes. All right. Well, that was refreshing. Very refreshing. Yes, normal, typical, useful. All right. So we've got a couple of date changes there for the Florida case. Most normal. And a cookie for everyone. And a cookie in every pot. Oh my goodness. All right. Trump must not have been there. Yeah, I'm not sure Giuliani wrote that one. Oh my goodness. Whoo, I'm on fire tonight, everybody. It's the cloning. It sounds professional for once. It does. Oh my gosh. All right. So we'll do a tea break and then jump into the DC motions. Practice makes perfect. Oh my goodness. Okay. So here we go. We've got documents 150, 151, and 152 filed again out of the District of Columbia. So this is just to remember, yeah, my hands are mad. All right, so just to remember, this is the election or the elector certification interference case here. Yes. So here we go. President Donald J. Trump, again, that's how you know it's his motion, respectfully requests the court, 1, briefly extend his deadlines to file replies in support of his pending motions to dismiss based off of constitutional, statutory, and selective prosecution grounds, collectively the non-immunity MTV. So motion to dismiss. I always do a 2 rather than a T, but to each their own. Anyway, from November 16th to November 23rd. And 2, extend his deadline to file replies in support of his pending motions to strike and stay by 2 days. Now, remember, the government's already filed a brief in opposition to all of his motions to dismiss. I only made it about halfway through that 80-page document, but that was what the government had filed before. So now they're asking for more time to reply to that. In support, President Trump states as follows. Background. The court previously set a deadline of October 23rd for Trump to file dispositive motions, including motions to dismiss. In accordance with this deadline, Trump timely filed his 3 non-immunities motion to dismisses, which address numerous significant and complex legal issues. They're not actually that complex, but okay. Additionally, Trump has filed a motion to strike inflammatory allegations from the indictment. Does everybody remember that? We went through that motion too, document 115, where he wanted any mention of him being involved in January 6th to be stricken from the indictment. So that's what that is. And a motion to stay the case pending a resolution of his prior and still pending motion to dismiss based off of presidential immunity, meaning he wants to pause the case until there's a decision made on whether or not he has absolute presidential immunity from prosecution. They're complex for him and his lawyers. Oh my goodness. True story. On November 6th, the prosecution filed its responses to these motions, including, with leave of court, an oversized 64-page omnibus response. All right. My bad. I thought it was 80. It was only 64. To President Trump's constitutional and statutory motions to dismiss. President Trump's replies are currently due Monday, November 13th, which is today, for the motions to stay and strike, and Thursday, November 16th. Now, by the way, as of recording this live or going live, he had not filed it. Simultaneously, President Trump has appealed this court orders limiting President Trump's speech, so the gag order. Following an extensive briefing, the court denied President Trump's motion to stay this order pending appeal. Thereafter, President Trump sought an emergency stay in the D.C. Circuit. The circuit court then entered an administrative stay while ordering an expedited briefing schedule requiring President Trump to file his opening brief on November 8th and his reply brief for this coming Friday. Moreover, the circuit court scheduled oral arguments for Monday, November 20th. Now let me make sure I've got that on our calendar, everybody. Okay, I do. So we've got the appeal of the gag order. That hearing is on the 20th, just to make sure. Accordingly, President Trump faces deadlines for 6 briefs on dispositive and other crucially important issues this coming week. At the same time, President Trump's legal team must prepare for oral argument in the D.C. Circuit on an unprecedented First Amendment issue. It's not really that unprecedented, but whatever. Go over Project 2025. Oh, dear. Oh, dear. President Trump seeks the requested extension so that he may better balance these conflicting obligations, while also continuing his trial preparations work, which cannot stop given the enormity of discovery and the potential March 4th trial date. Discussion. Under Federal Rule of Criminal Procedure 45B1, the court may grant an extension for good cause shown at any time before the originally prescribed or previously extended time expires. As the court knows, President Trump and his counsel have worked diligently to comply, all right, with deadlines in this matter and appraise the court of relevant legal authority and arguments. Are they relevant, though? I'm getting catty, everybody. It's getting late. So that your honor may make fully informed decisions. Indeed, President Trump has filed numerous substantive submissions nearly every week since this case began. The requested extensions will allow President Trump to focus on and complete each filing at a reasonable cadence rather than all at once. The requested extensions will not cause any prejudice, as all filings will still be completed within 11 days or fewer. It will not affect any other deadline. Likewise, as several significant previously filed motions are fully briefed and currently awaiting determination, the requested extensions are unlikely to affect the court's review process. Therefore, President Trump respectfully requests the court grant the requested extensions. Okay. So... Yes. All right. So that's his motion. So let's hear what the government has to say. Here's the government's one-page response. Coming up. Yeah. I mean, there seems to be a lot of people frustrated with the quantity of work involved here. Oh, my goodness. All right. So this is the government's opposition to defendant's motion for an extension of time to file reply briefs. Okay. So if it's in green, it means it's the government. The defendant seeks yet another extension, this time for a deadline for filing replies in support of his motions to dismiss the indictment, to strike allegedly inflammatory allegations, and to stay the proceedings pending resolution of his presidential immunity claim. The court should deny the defendant's latest attempt at delay. The defendant's motion does not establish good cause for any of his requested extensions. And then we have footnote 1 here. Regarding the defendant's reply in support of this motion to strike, the defendant seeks an extension until Wednesday, November 15th. Although the government did not realize it when it indicated to defense counsel that it opposes his extension motion, the defendant's reply is not due until Thursday, November 16th. Oh dear. Court scheduling order making the defendant reply due within 10 days of the government's filing of its opposition brief on Monday, November 6th, the court should thus deny the request extension as moot. Well, that's important to note if we have the dates wrong. He claims past diligence when his repeated prior extension requests suggest otherwise. He mentions that the government filed an oversized 64-page omnibus response to his 65 pages worth of motions to dismiss. Oh, no, come on. Are we getting petty? Based on constitutional and statutory grounds, wrongly implying that the government's single organized opposition imposes some greater burden on him than the 2 separate 45-page filings that the government was entitled to file under the local rules. Oh my gosh. I think we're getting frustrated, everybody. I think the government's getting frustrated. And let's see what else he has to say. I'm not saying he's wrong, but I'm saying he's getting a little upset. When did we stop? That's a good point. Suggests he needs more time because he's appealing this court's appropriate Rule 57.7 order. But the defendant should not be permitted to derail the pretrial schedule by pointing to the rapid appellate consideration few other defendants enjoy. That's a good point. In any event, the defendant is represented in his appeal by 3 additional counsel apparently retained just for that purpose. There's no reason that his separate counsel of record here cannot meet this court's deadline while his appellate attorneys prepare for oral arguments. More fundamentally, the defendant's latest extension motion risks preventing the completion of briefing of the defendant's constitutional and statutory claims, including his double jeopardy claim, which the government has explained should be decided promptly and in conjunction with the defendant's presidential immunity claim. His motion should be denied. Whoo! Spicy. It's getting hot. It's getting spicy. Jack's getting frustrated, everybody. He's getting frustrated. Oh my gosh. got a little spice going on there, a little spice. He gives it, think they're getting frustrated. I think this really is going, a part of the strategy is to annoy the other side. And that is a strategy some attorneys use. And I think it's out in full force in these cases. He's tired of him. Yeah, I think so. And, but this is just the beginning. This is a marathon. So he needs to pace himself. If he's going to make it through, he's going to have to pace himself. All right. So then now we've got an order. So this is the answer from the court. So pink, of course, means it's from the court. Defendant's motion for extension of time to file reply briefs is hereby granted in part and denied in part. Man, just check in. It's 50-50 on everything. And the court's prior deadlines are hereby amended as follows. Defendant may file any reply in support of his pending motions to dismiss based on constitutional, statutory, and selective prosecution grounds by November 22nd. And the defendant may file any reply in support of his pending motion to strike and motion to stay by November 15th. Signed, Judge Check-in. So, yeah, she's got to be careful. She's walking on a tight line here. All right, let's add it on. So we've got November 22nd is when his reply is due. So, DC reply. Fingers aren't working. Here we go. Reply. Due. Okay. Whew. And then... so November 15th on the motion to stay. So motion to stay for DC is due. So just slight changes, but still changes nevertheless. So we have this reply is changed, and then the motion to stay is due on Wednesday. So what do we think? Are we okay with that? Are we okay with her shifting the schedule down a little bit? Seems like you should avoid writing so you're thinking and recovering. True. I try to make small movements for sure. And I tried to, what's a motion to stay mean? So, yeah. So motion to stay is that he's asking her to pause everything until his motion on dismissal based off of executive privilege is decided. So he filed saying, I've got absolute privilege. And this was the Nixon v. Fitzgerald case. Don't get me started. And so he said, I've got an absolute privilege. So everything I did was fine. And until she decides whether to approve or deny that motion, he's saying everything should be paused. And then once that's approved, one way or the other, then it can go forward. So that's his motion to stay. So his motion to stay. So stay just means pausing the trial until another issue is decided. That's tomorrow. Yeah. Is it? No, I think we're close. It's Wednesday. We're close. Denied. Yeah, I think that, I don't know. Wednesday. Yep, Wednesday. I would be shocked. If that won. We would be overruling some precedent. Delay tactics, perhaps. As far as a yes or no would go, if I had to answer yes or no, I'd say yes, delay, but a little delay, a small delay. And I think she definitely is trying to be extremely careful because, as all the judges are, well, maybe not all of them, but as most of the judges are, because they're trying to be careful for any appeal issues. He doesn't have executive privilege. No. No, that particular motion had a lot of red pen on it. That was a see me after class motion. Well, yeah, I'm not naming any names here, but I'm just saying I couldn't even get a college paper extension. Oh my gosh. Oh, I know. Yeah, which ones? I'll leave that up to you, Hitch. You guys can figure that one out. Okay, so the last thing for tonight. Oh my gosh. There's executive privilege, everybody. Don't get me wrong. There's executive privilege, but there's limitations. So there are multiple cases that address that, and they were all incorrectly cited in his motion. So that's why I laugh. All right, here we go, everybody. Here's our last bit. So this is, again, just to bring us back to the New York civil case, a little update on that. So we have the defendant's witness list. here. And within the witness list set out by the defense team, they have 12 expert witnesses listed. So these had to be filed before trial. So these are pretrial motions. So defense witnesses include fact witnesses, so people just coming in and giving factual information. So we would call those lay witnesses. And then they have expert witnesses, who are people with specific knowledge of certain areas. So they have 11 of them listed here. So what has happened is that the AG's office has written this letter to Judge Engoron asking to be able to present a limine motion to exclude some of their experts. So she's asking permission to go forward to make her argument, because some of these experts she doesn't feel are appropriate, and she sets that out in here. So I thought that would be really interesting to kind of go through and figure out which of the experts she feels are just not appropriate. Now, if anyone was following the case today, we know Don Jr. testified, but a lot of his testimony involved watching some kind of a, what are they calling it? Like an infomercial, maybe, was what they were calling it, or a descriptive video of properties, I guess, and it was multiple hours. Going into different descriptions of the different Trump properties. Now, the AG's office, a PowerPoint, thank you, PowerPoint, whatever. Potato, PowerPoint, infomercial, whatever. But the AG's office was like, we object. And the judge was like, it's fine. Let them play their show. It's fine. And so they were denied on that objection. A video would have been more enticing. Oh my goodness. Oh my gosh. So I think that the AG is going to have a bit of a uphill battle ahead of her. She's going to be asking for several of their, and I'll take you through this, but several of their experts to be tossed as not qualified. Now, she can ask all she wants, but I think, especially after today and listening to kind of the responses Judge Engoron had, I'm not sure he's going to kick these experts out. He may just let the defense put on whatever case they want to put on, just to make sure that, both sides have equal amounts of time. So we will see what happens. But do they record the New York fraud case for internal court use? It's all transcribed. All of it is being taken down. So I'm not sure if they're actually recording it. I would assume so, just in case there were any problems. But yeah, it's an interesting situation. And I think Judge Engoron's like, you've had 6 weeks, so they get to have their 6 weeks. And I think part of that will be him letting any of their witnesses come in that they want to have. We'll see, though. We'll see what happens. So let's get into this letter here. I love the court sketch. Yes, I saw that too. Oh my goodness. Oh my goodness. And didn't he make some comment like, make it look good? And the sketch artist is like, whatever, creepy. Will they delay the trial for his sister? I don't think so. She's not actually listed as one of their defendants or as one of their witnesses. We'll see. The letter looks bad. Well, I'm not sure. Let's take a look. Here we go. So, Dear Justice Engoron, and this is the proper way. If you're asking for a hearing and you're filing it, we do this all the time in court. We just want to make sure. Oh, I see what you're saying. Yes. Oh, that's very sad. Sorry, everybody. I had forgotten she had passed. Yes. So I was thinking of Ivanka. I don't believe so. Although I wouldn't be surprised if it was delayed. Honestly, if he did push things back a little bit for that. So, yeah, he doesn't have to be there. Yeah, true. I wouldn't be surprised if he did pause it, but I'm not sure. Yeah, I had totally forgotten about that, everybody. So much going on in the world. So much going on. Sad, sad story. All right, here we go. Let's dive in. Here we go. Dear Judge Engoron, on behalf of the Office of the Attorney General, we write to advise the court that the Attorney General seeks leave to make an oral motion in limine tomorrow afternoon to preclude the testimony of 4 experts. So this has already happened. Defendants have included on their initial list of witnesses Stephen Laposa, Jason Flemons, Steve Witkoff, and David Miller. For the reasons discussed below and to be addressed more fully during oral argument as permitted by the court, the testimony of these experts should be precluded because 1, the opinions to be offered by Laposa, Flemons, and Witkoff are no longer relevant in the light of the court's September 26th decision and order. So that was his ruling on the summary judgment, granting plaintiff's partial summary judgment on plaintiff's first cause of action for the fraud under Executive Law, Section 6312. And 2, Witkoff and Miller were designated solely in rebuttal to plaintiff's experts, whom plaintiff determined there was no need to call. So there is nothing for either of them to rebut. Okay, so defendants designated Stephen Laposa as an expert witness in their affirmative case and disclosed his report May 26th of 2023. This report and accompanying affidavit, like the expert reports and affidavits cited below, for the others were also submitted by defendants to the court as part of their summary judgment papers. Dr. Laposa's report discloses that he will offer the following 6 opinions concerning property valuations. 1, disparate but legitimate valuations of specific property may coexist. Property valuations are highly subjective, and accordingly, there may be wide valuation differences between stakeholders. 3, appraised market values are different from appraised investment values, producing wide differences between the two. 4, various stakeholders have different outlooks on economics and market trends that explain wide variances in estimated valuations for a specific property. 5, appraising a trophy property presents unique challenges that explain disparate valuations between an appraiser and an owner. And 6, plaintiff's allegations fail to properly consider significant real estate economic and capital market trends from 2011 through 2021. So this case is so boring. I mean, if you just look at it from a legal perspective, it's a very boring case, in my humble opinion. But, nevertheless, here we are. So we've got defendants also designated Jason Flemons as an expert witness on accounting procedures and disclosed his expert report May 26th. The report discloses he will offer the following 5 opinions. 1, the GAAP provides significant latitude for reporting asset values in personal financial statements. 2, industry standards permit financial statements that contain GAAP. So this is general accepted accounting principles. Exceptions to be issued, and the standards that pertain to accountants' reports accompanying financial statements provide different reporting formats that may be used depending on the presence and significance of such GAAP departures, even when the effect of the GAAP departures has not been quantified. 3, the notes to Mr. Trump's statements of financial condition and the accountants' compilation reports accompanying the SFCs collectively and expressly disclose the methods used to determine the value for specific assets and identified significant departures from the GAAP, which did not preclude their issuance under authoritative professional and industry standards. 4, the complaint alleges violations of GAAP that are based on flawed accounting analysis. And 5, the supporting documentation provided to the outside accountants retained to perform the compilations clearly identified exceptions to the requirements for estimated current value under the GAAP and accurately described the information that was provided by outside professionals. Again, we just say GAAP. Thank you, Lisa. I don't want to offend any accountants. Okay, I've got nothing but love and respect for accountants out there, okay? All right, we'll call it GAAP now. Defendants further designated Witkoff solely as the rebuttal expert witness in response to plaintiffs' valuation experts, Konstantin Korologos and Lawrence Hirsch, and disclosed his rebuttal report June 30th. Okay. Witkoff's report discloses that he will offer the following 2 opinions concerning property valuations. The Doral property is worth far more than the values that are set forth in the 2011 through 2021 SFCs based on the forward-looking perspective as opposed to a conservative buyer-driven analysis. and Mr. Korologos' assessment of defendants' valuations of 40 Wall Street failed to consider residential conversion of the property that would result in significant increase in value. The valuations and accounting issues raised in this case with respect to the preparation of the SFCs have already been resolved in plaintiff's favor by the court on summary judgment. The court held in its decision that clear, indisputable documentary evidence proves defendants overvalued the assets reported in the SFCs. On a record that included the Laposa report, Flemons report, and Witkoff rebuttal report, along with affidavits from Laposa, Messrs. Flemons and Witkoff attaching and summarizing their reports, the court reviewed in detail the valuation methods actually employed by the defendants for multiple properties and held no genuine issues of material fact preclude findings that defendants were liable for fraud. After reviewing the representations in the SFCs and the valuation methods used, the court specifically held, and I have to take a tea break, everybody, before I get into that. One moment. Okay, so this was the holding in the summary judgment order. The value of the triplex was fraudulently inflated from the SFCs from 2012 to 2016. The value of Seven Springs was fraudulently inflated from 2014. The value of the rent-stabilized apartments at Trump Park Avenue was fraudulently inflated in the SFCs from 2014 to 2021. The value of 40 Wall Street was fraudulently inflated from 2011, 2012, and 2015. The value of Mar-a-Lago was fraudulently inflated in the SFCs from 2014 to 2021. The value of Aberdeen was fraudulently inflated in the SFCs 2014 to 2019. The value of certain golf courses was fraudulently inflated in the SFCs from 2014 to 2020 by including a brand premium and ignoring appraisals. The value of certain golf courses was fraudulently inflated in the SFCs from 2014 to 2020 by valuing membership deposit liabilities at zero. The value of cash was fraudulently inflated on the SFCs from 2013 to 2021. The value of the Vornado partnership properties was fraudulently inflated in the SFCs from 2014 to 2016 and 2021. And the value of the licensing deals was fraudulently in the SFCs from 2014 to 2018 and 2020 to 2021. So that's what's been set out in the order. Similarly, the court resolved in plaintiff's favor the accounting issues that Mr. Flemons' opinions will address. Notwithstanding a record that included Mr. Flemons' report and affidavit, the court has already determined that specified valuations of the SFCs, along with the notes concerning those valuations, were false and misleading. Right. In addition, Mr. Flemons' opinions concerning the gap departures and disclaimer language in the SFCs are not relevant because the court held on summary judgment for the third time that the disclaimers do not insulate defendants from liability because the language puts the onus for accuracy squarely on the defendants' shoulders. And the court further held that these disclaimers were insufficient as a matter of law to insulate defendants from liability because they did not particularize the type of fact misrepresented or undisclosed and were unquestionably based on information peculiarly within the defendant's knowledge. Whew, goodness. The court noted in its decision that the only issues remaining for trial were plaintiff's illegality claims under 6312, the second through seventh causes of actions which require additional proof of intent to defraud. So that's what this entire trial is about. The amount of disgorgement and determination on the third through ninth prayers for equitable relief sought in the complaint. Again, disgorgement means to put the person back where they were before. So any kind of loss that was done needs to be assessed and taken care of. Based on the court's decision, plaintiff's affirmative case has been appropriately narrowed to establishing defendant's intent to defraud, the amount of the disgorgement, and facts bearing on the plaintiff's entitlement to the forms of equitable relief not already awarded by the court. Defendant's affirmative case should be similarly circumscribed to focus only on the issues that remain in the case relevant to plaintiff's second through seventh causes of action. disgorgement, and the additional prayers for equitable relief. The expert opinions of Laposa, Mayers, Flemons, and Witkoff have no relevance to these issues and should therefore be precluded. And then here's footnote number 1. So why are the defendants not arguing no damages? Great question. I continue to ask that question. And I do not know. Mr. Witkoff's testimony is particularly irrelevant since there's no allegation that the Doral property was misvalued, as it was subject to multiple appraisals by Deutsche Bank during the pendency of the loan. Likewise, a residential conversion of the 40 Wall Street property was never the purported basis of valuation for the property on any of the SFCs at issue. All right, and this trial, occurring nearly 6 years after the DAI filed this action, will resolve disputed issues of fact. It will not be an opportunity for defendants to present additional or different evidence that was before the court on the motion for summary judgment. Yeah, loan, it's the Deutsche Bank. I am trying so hard to say that name correctly. Took it too far, too many words. Tea break. Yep. Super tacky, really? Oh. I heard he's big into marble, like he's a big marble fan, but I don't know. I've just heard that. Okay, then we're citing case law here. Excluding expert witness from a bench trial where value of testimony is exceedingly minimal and easily outweighed by even the slight danger of waste of time and undue delay that would accompany the testimony of expert witness whose opinion could at best be marginally useful to defendants. And then she's citing more case law here, just setting up that it would be a waste of time. Indeed, the court's holding that defendants fraudulently inflated many assets of the SFCs on summary judgment record that included reports and affidavit testimony from these proffered experts further confirms that their opinions are irrelevant, even as to the issues that may have been decided. Footnote 2 here. To the extent defendants attempt to argue that their expert opinions are relevant to the issue of materiality on plaintiffs' illegality claims for making a false financial statement and committing insurance fraud, such an argument is without merit. The materiality issue under those penal law claims is whether the extent of the inflation already determined by the court is material in relation to the overall value of the asset as set forth in the relevant SFC, not whether some hypothetical value defendants could have come up with based on valuation methods offered by defendants as expert but not actually employed by defendants at the time would reduce the degree in inflation. It's a valid point. Citing case law here, the district court did not exceed its allowable discretion in excluding this portion of the expert's testimony. Whether the prices were fair was not an element of any crime with which defendant was charged. The principal issues at trial were whether a reasonable investor might have found the misstatements important and whether defendant intended to deceive the purported victims. Whether a victim later makes a profit or loss on the bonds it purchased from the defendant has no bearing on whether defendant's misrepresentations were material and whether defendant intended to deceive the purported victims. Thus, the district court did not exceed its allowable discretion in excluding a portion of the expert's testimony. All right, and back up we go here, citing the Raskin case. And let's see. As we read the opinion, the district court concluded the expert's report was probative of no material fact from which we deduce that it was, in the district court's view, irrelevant and inadmissible. We therefore can review this ruling as evidentiary in character. Moreover, the trial is not an opportunity to debate what Mr. Trump's actual net worth was in any given year. Plaintiff has alleged and has already proven that many of Mr. Trump's assets were fraudulently inflated in the SFCs. His actual net worth in any year or the correct estimated current value of any particular asset in the SFC is simply not relevant, either to the issues as framed by the complaint or, more importantly, to the issues that remain following the decision. And then she's citing case law again. So she's saying that what those actual numbers are isn't really what's important because they've already been found to be fraudulent. That's what she's arguing. Additionally, testimony that relates only to issues that are no longer in the case after the court's summary judgment ruling, which will be excluded as no longer relevant to any issue in the case. So again, she's saying these were things were already decided on summary judgment. We don't need to rehash them. Finally, the court should preclude Messrs. Witkoff and Miller from testifying at trial for the additional reason that the defendants designated these two witnesses solely as rebuttal experts in response to experts disclosed by plaintiffs who have not testified, and therefore there is nothing in the record for them to rebut. And footnote 3 here. Mr. Miller's expert rebuttal report was disclosed June 30th and provided opinions responsive to those proffered by plaintiff's insurance expert witness, Tom Baker. Okay, defendants similarly submitted this rebuttal report to the court as part of the summary judgment paper. All right, back up. As the First Department has explained, when a party is offered no testimony for an expert to contradict, impeach, or discredit, it is an error to admit the expert's testimony under the guise of rebuttal. And then we're citing case law again here. So whether to permit the introduction of rebuttal evidence rests within the sound discretion of the trial court. For the foregoing reasons to be more fully discussed during oral arguments as permitted by the court, plaintiff will seek an order precluding defendants from calling Dr. Laposa, Messrs. Flemons, Witkoff, and Miller. So then let's just take a look here at their list that they're planning to call here. So again, we've got our fact witnesses, and then we have our expert witnesses. So let's take a look. Putting expert witness on the stand is a lot more restrictive than shown. It really is, Jim. It really is. Would the judge be in violation for giving the opinion of value from the bench? No, I don't think so. Not in this particular case, because we're really specifically dealing with a very specific area of New York law. So this section that everything has been filed under here, 6312, really changes the rules. So that's what makes this different than any other case. All right, so let's take a look. Mark Abelman, Timothy Barnes, Swasi Bate, Neil Becker, Donald Bender. So he testified for the state already. I don't know all of these that have testified for the state, but Bernie, Blakely, Brunette, Carpenter, Castro, Jamie Cho, expert informed opinion. Right, yeah, so expert opinion specifically means that you qualify under one of our rules of evidence. So 703 governs expert witness testimony. Actually, instead of just writing it out, let me just grab the rule real quick. Let me grab the rule, everybody, real quick. Instead of just writing it. 1 minute. Okay, here we go. So, expert witnesses have to qualify under the rules of evidence. So, they look to a specific basis. They can base an opinion on facts or data in the case that the expert has been made aware of or personally observed. If experts in the particular field would reasonably rely on those same kinds of facts or data. So we've got a particular basis for their opinion, and we've got rules setting out again how they're allowed to testify. So they've got scientific, technical, other specialized knowledge that will help the trier of fact understand the evidence to determine a fact at issue. It has to be based on sufficient facts or data. Testimony is a product of reliable principles and methods, which is one of the biggest arguments people have against a lot of experts, is that their techniques are not based off of reliable principles, and then that the expert has reliably applied the principles and methods to the facts of the case. So those are the rules we've got to follow for experts. The other rules are for our lay witnesses. Expert witness for engineering accidents. He thinks he's a lawyer now. Well, you know, honestly, I missed one here. Honestly, if you have a specialized knowledge, I mean, of course, that's the My Cousin Vinny expert witness that we probably all remember. If you have a very specialized area of knowledge, I mean, and you can show that you have that specialized area of knowledge, you should be good to go as a witness, as an expert. So, okay, so David Cohen, let's see, Constantine, Cornell, Courtney. I'm just trying to see if I recognize any of these other, Emil, Dylan, Christopher. I don't know any of these. I've not heard of any of these. There's a couple that were called by the state previously. But let's see who else we've got. Flores, Frank Fried here, Holdman, Gonzalez, Goodman, Graff, Griffith, High Harris, Harris Hawthorne. Nope, none of those. I don't know any of these people here. Johnson K, can I get this one, this one, this one, this one? So this is one of the experts that they are contesting here. See, Danny DeVito. I know, I thought that too. I'm like, what? Is it a cousin? I don't know. Here we go. Martin, this one here. Mazar's corporate representative. That's not very specific, is it? I wonder who that would be. Who's their corporate representative? I don't know. All right, so McConnie Miller. And then keep going. Whoa, look at that name. That's amazing. Okay, and here, so again, none of those were on the state's list. And then, let's see, did we have, okay, Miller, I think was another one. Was Miller another one? I think so. All right, sorry everybody, I'm getting sidetracked. I gotta focus here. Here we go. I'm really interested to see if they've pulled any of the other states' witnesses in here. So Donald Trump Jr., and Eric Trump are all on their list, but Ivanka is not on the list. Are they bringing all of these people up? I don't know. It's possible. It's possible. And remember, we had, and then Wesselberg. Okay, so we've got some Wesselbergs in here. So, you know, the state only had 28 witnesses and a couple rebuttal witnesses. Meanwhile, we're over 100 at this point. So, another corporate representative here. And this was another one that the state objected to. This one. And any witness included on the plaintiff's witness list. So plus 28. So I guess Ivanka would be included because of that. But there you have it for that. The Trumps didn't know much on direct. Yeah, I know. How long would that take? Well, hopefully not too long. So the trial here is set to, let me just get the calendar out of the way. Ooh, I wish my hands worked. There we go. So we are set to finish the New York civil trial by the 22nd. The 22nd. So we are into the first day at the moment. So here we go. First day at the moment. So we've got 6 full weeks. So 6 weeks for each side. Again, the state had 28 witnesses and they have 128 witnesses. I don't know how they're going to technically get through all of it, other than I don't know that the state will have much cross-examination, and I think that will significantly reduce the amount of time. Because if you're just doing a direct examination and just really setting it up and knocking it down, you can get a couple, even up to a few witnesses each day, depending on how much. We'll bog down the court even more. How's that okay? Well, again, I think, Judge Engron's in a tough spot in one piece because he wants to make sure he gives enough time to the defendants so that they feel like they've been able to be heard. We need to have a fair process. But on the other hand, we're looking at intent. We're not retrying the actual worth of his properties. And I think that's what's going to tangle up the defense constantly, is that they're not here to prove that his numbers were correct. We already know his numbers were wrong. So it's a waste of time to prove that they were correct. Meanwhile, they think that that's essential because that's showing intent. They're like, hey, we think that these numbers are correct. Therefore, we didn't have any intent to defraud. So they're seeing it as a key element to their defense. Meanwhile, those decisions have already been made. It's the level of intent. So it'll be interesting to see what happens. It will. I'm not sure. 6 weeks, I think they could get through it. But again, we do have the AG who's saying, look, I'm not sure all these experts are really necessary. They'll probably really have a very truncated cross for almost all of them, I would imagine. I think we saw a little bit of that today, even with Don Jr. There just isn't, they're not going to want to take up a whole bunch of time on cross. It's just not necessary. Mods are amazing tonight. Yes, amazing every night. Moderators are so amazing. I'm so thankful for all of them. So it'll be a fun and interesting week. It's getting deep, yes. It'll be a very interesting next few weeks. But I'm not sure if Don Jr. will be testifying again tomorrow or not. Did he finish today? Does anyone know? I wasn't able to get the last of it. Truncated. Maybe to confuse the issue. I think so. And I think this was kind of like, there's a couple of different strategies. There's some people that are very careful with their witness list. And this was something that Judge McAfee in the Georgia case was talking about. He was saying, I want you to be as thorough as you need to be, but also you don't need to put everything in the kitchen sink in your witness list. So I would say defense really did do that here. They put in a lot of probably unnecessary witnesses just to cover anything that they may need. So they just might not even need all these witnesses, but wanted to make sure they were there and had the opportunity to call them if they found them to be important. How long will they let him delay the courts? Oh, that's a good question. It depends on each state. He's done talking at 3:30, talking to reporters. Okay. So I think that's a good sign because too, if they released for the day, if they dismissed for the day after his testimony because of the PowerPoint that they were watching, I think that gives us a good kind of idea of how the questioning is going to go. They tried to, right now, okay, so according to my docket, I have a hearing in the Court of Appeals that was supposed to be heard today on that motion for summary judgment, but I cannot find the original order where I put that down. So this is a question mark. This is a soft hearing, so I may be wrong. I've not seen anything reported on it. I've checked the docket for the appellate division in New York, and I haven't seen anything. So I'm wondering if I have the dates wrong on it. But there is a hearing that's supposed to be scheduled for that appeal because that motion for summary judgment is being appealed. But I had today down as the date for the hearing. You're convicted of felon, you can run for president. Well, there is no way to make sense of it, Sheila. It doesn't make sense. It just doesn't make sense. Absolutely does not make sense. Yep, there's no way to make that work. It doesn't make sense because nobody figured that there would be an issue like that. So, for running for president, Trump's all go to the same president. Oh dear. Oh, I don't know what that. Talking about the financial fine. Yes, exactly. It's the financial fine. So, and, $250 million is, that's some pocket change. Do people use change anymore? Is that phrase even relevant? I don't know. It's a lot of money. So, he's so, what's the word I'm looking for? He's so restrictive with his money. It's, of course, a huge issue for him to be looking at a $250 million fine here. So this is huge for him. So they're really going to want to kind of figure out all the levels. Trying to figure out how the January 6th people running for senator. Yeah, I saw that too, Navy vet. I saw that too. And again, that section of the 14th Amendment, Section 3 of the 14th Amendment applies to anybody who has previously sworn an oath. So if they were not representatives before, if they were not in political office before the insurrection, it cannot be used against them. But if any of them had held an office, then they could be disqualified. Is it possible to be greater than 250 million? No, and that's because of how the complaint for the New York case was written out. So the way that she set out the disgorgement amount based off of the contracts, she actually put together an equation of how she came to that number. So 250 million is what she feels was lost because of the information. So that's how that number came about. Was Jacob ever in the military? He would have sworn an oath to the Constitution then. Oh, excellent point, Daisy. Excellent point, and I don't know. It's a good question. Lawyers swear oaths to uphold the Constitution, right? Does that qualify? I would say so, absolutely, David. I would say if an attorney takes an oath to the Constitution and is involved in an insurrection, no, they would not be able to run for office. Nope. Military should count as well. And we had some Confederate soldiers that had that very issue happening after the war. There were some soldiers who had wanted to run for office. And so there was actually a provision passed to allow many of them to run. So because Congress can do away with the Section 3 piece if they so choose. And they did do that. He was in the military. Really? Really? Oh, that's very interesting. Okay. Then he could be challenged. He absolutely could be challenged if he already took an oath for the military. Yep. Ooh, good point. Good point. Got 5 deferments for... Oh, we're talking about the shaman. We're talking about the... Would it be any office that had to sign an affidavit to run to uphold the Constitution of the state? Any publicly held office, any elected position, or... It could be a position where you're hired as support for an elected position. So many times, like the staff and various support people will also need to take an oath depending on which position they're helping with. So like the state auditor would have taken an oath, of course, or the county auditor, but then the people that work for the auditor, some of them in some places may have also taken an oath. So it depends on how your jurisdiction's set up. Also, police and sheriff, absolutely, Navy, you got it, absolutely. Anyone who has a badge, anyone in like juvenile court officers all take oaths. Everybody has to take an oath. If you're working for the government, you've got some kind of an oath that you're taking pretty much if you are working for an elected position. So that support staff would be included. Oh, yes, absolutely, David. Yeah, absolutely. No, we've, the support's got to take it too because they've got to be in compliance with the Constitution and the law as well. That one commissioner was removed. Yes, in New Mexico. Oh, thank you. Thank you for that. Celebrating. Woohoo. Yes, so New Mexico was a county position fella who was part of the insurrection, and he was taken off of the ballot by the court there in New Mexico. Yep. Didn't take an oath to the Constitution either. Well, that's incorrect, Estelle. He did. I think you must be being sarcastic, I'm assuming. Oh, no, his oath actually is the only oath set out in the Constitution. You have to take the oath. Yes, absolutely. I've never taken an oath. Does that mean I can run amok? Well, technically, I mean, yes, I guess. Now, I cannot. I've taken many oaths, actually, so I cannot be part of an insurrection. Yes, he did. He did. Yeah, that's what he said. That's what I thought, Estelle. I got you. I was like, wait a minute. I think she's joking. Yep. I got you. That's what he said. Oh my goodness. He meant it. Right. Well, whether he meant it, exactly. But there was a whole shavil, right? There's a big thing about whether or not whose Bible you're going to hold, and the first lady always holds the Bible, and the hand goes up. I mean, it's a big to do. We were all, we all saw it. It's all there. And those words are actually written into the Constitution. So, that's not really why is this hearing? I think we're doing okay so far. I think some things have been moved, but the calendars are going to get tight, everybody. These deadlines are going to start getting real tight. When we started, November only had about a handful of things, and then it just totally is starting to explode. And especially once we start getting the Georgia motions and things starting to run, at this point, it's going to start filling out pretty quick. Touched 2 Bibles 2 times, once for the oath and once in front of a church. Well, that could be. That could very well be. What happens if you're not religious? What do you swear? So that's a really great question, actually. So let me just show you something, because I've got my rule book here, and because I enjoy because I just have to share. So anytime you're doing an oath or an affirmation to testify truthfully, so this is our legal standard. It says, before testifying, a witness must give an oath or affirmation to testify truthfully. It must be in a form designed to impress the duty on the witness's conscience. So it's the same standard legally. Like, you don't actually literally have to have a religious book that you're putting your hand on. You just have to say it in a way that truly impresses upon you that you are truly swearing an oath. But what you actually put your hand on, like the technical ceremonial piece of it, is really not that important. We affirm in the UK. Yeah, there you go. You got it, Deborah. Yeah, do you swear or affirm? Exactly. Now, there may be some courts still that have a Bible or that use some of that kind of language still, but technically that's in violation of the Constitution. So there's a lot of cases where that's been argued. Now, don't get me wrong, the 10 Commandments have been placed on a government property before. That's different. But this idea of actually putting your hand on a Bible before testifying in court, that is not acceptable. That's been held repeatedly. That's not acceptable. And again, swearing an oath, and I would say swearing an oath to become president, you would not be required to put your hand on a Bible. With how the law is actually written, just to be technical about it. For anyone who's wondering, a lot of people do wonder that. A lot of witnesses I've had several witnesses that just look at me funny when there's no Bible. It's like, you just raise your hand. Well, where's the Bible? Like, we don't need a Bible. What are you talking about, a Bible? Yep, swear or affirm. Exactly. Is there still talk about anything coming from Bedminster? Yes, I think, again, the process is slow, everybody. It's slow, like a military tank, but thorough. And so I believe we're going to be seeing some things coming pretty soon. I'm not sure exactly where they're going to be coming from, but I definitely believe we've got some. We have prayer books, but I'm curious about that. Yeah, I mean, you can. The Torah is a giant scroll. Well, yeah, I mean, that's hard to, you could probably use a copy of that, condense that down somehow. But I mean, right? Actually, it's really interesting, the different types that can be used depending on your belief system in the military, because there are a lot of different ways of kind of respecting those different traditions. And so they want to make sure they've got lots of different options available for soldiers. So, I think that's always interesting. And I know too, actually in one of the things that's very interesting is, if you'll note, in our prison systems, one of the most controversial is that there had not been places of worship, proper places of worship for Native Americans. And so a lot of our indigenous population who are in prisons had nowhere to properly worship. And so specific places needed to be created for them. So that was a huge, huge issue legally. So we kind of have to make accommodations depending on what's going on. What happens with atheists? Well, it's just, you just swear or affirm. So if I don't know. Is it, what's that guy's name? What's his name? I think there's some guy that's a big, I can't remember. I don't know. Pick your book. Pick your book. Pick the book that says, I believe in whatever I want to believe, and then you can swear on that if you want. Adding the Jedi religion. No, I don't know about that. I can swear in a comic book. Yes, George Carlin, the pillow guy. Oh my goodness. No, I don't know about that. Oh my gosh, a cookbook could be. It could be. So the key though is that, it's a religion and we acknowledge religion based off of tax codes. So if you qualify as a religious entity under the Internal Revenue Service tax code, then you have a religion. So I suppose technically the Jedi could be, if they are if they have registered as tax exempt, could use some of that. Well, I do try. I've had years of experience, but mostly it's OCD. Yeah, they're not taxed. Exactly, Leo. You got it. So you're wrapping up. Yes, I am. I am starting to wrap things up a little bit here. I am going to. Carl Sagan. All right. I mean, pick your person. If it's registered with the IRS as a religious organization. Actually, I believe there was a U.S. Supreme Court case, just as a quick side note. I've got to post my freedom of religion cases will be posting pretty soon. But I know there was a case involving soldiers who pass away and are buried in government cemeteries. And you can have your religious symbol put on your tombstone. And so, of course, we've got, all the different major religions of the world. But there was a soldier who was Wiccan, and they would not put a pentacle or a pentagram. Pentacle, I guess, is in a circle. They wouldn't put the star, the symbol, on his tombstone. And so his family was so offended, they took that all the way to the U.S. Supreme Court. And they held that it's a religious symbol and that it's a valid religion, and to accommodate that soldier's request on his tombstone. Pentagram. Thank you, Kristen. Pentagram. Thank you. I always think of the Pentagon, so it always messes me up. I apologize. I mean no offense. Oh my goodness. Points down. Well, the pentacle, yeah, I mean the Wiccan sign is pointing up. I do know that. Can Bedminster be seized since there's a cemetery on the ground? That's a great question. Ooh, that's such a good question. I don't know. It's kind of weird. I kept thinking, is it zoned properly for that? I mean, you have to properly be zoned in order to bury a body. I'm just putting that out there, everybody. Okay. I'm not talking about your hamsters and your cats, but if it's a human, you got to be zoned properly for that. What happened to your wrist? Oh, thanks. Yes, of course. Yes, I had a little incident. But I'm healing. Yes, so they should mow the lawn. I know that whole situation really is makes me uncomfortable. So yes, I had a little incident. I was having a night terror involving a car engine, and I woke up and my computer and my table were on the floor and my hand was all busted. So yeah, it was. I've got no legitimate reason. It was completely random. Cage finding. Documents were buried. They could be. I don't know anymore. I would say all bets are off. There could be documents in there. I really have no idea. But yes, so I fought the table. Well, I think it's the table, we were both equally harmed. I would say my computer and neither one of us were winners. We were both losers in this situation. Encountered a ghost, defended yourself. Well, and again, as I kind of started out this live, I was saying, I talked to my doctor and she said that that's a common side effect for one of my medications. And so, because I had said to her, I'm not punchy. I'm not a punchy person. And so she's like, well, stop taking this medication. So, no, the laptop's not been taken in yet. I need to. Oh my gosh, do I have a YouTube channel? I do. Now, unfortunately, I've not been able to upload these last couple of days. Honestly, I've just haven't had the wrist movements to do it, but it's on the top of my list. I do need to upload, but I do have a Tube of You channel. It's the same as my name here. 3 a.m. Deborah. Yes, have a great night. Thanks for moderating as always. Wonderful to see you as always. So Yes, yes. So yeah, it was I need to take it in. I probably should take it in. It's not supposed to be green, right? It's green. Oh no, it's okay. It's okay, Blue Jean. It's okay. The bottom line out of the rubber to the road, which is my new favorite saying, is that they're just blowing a lot of hot air. Nothing they're saying is accurate. It's okay. That's the bottom line. Did I break anything? So they didn't say the word break. It's more of like a crunch. So that's probably too much, everybody. I've said too much. So I've got more crunching going on, really. So watch your hard drive. Yes, I've moved everything over. Although I have to tell you, I'm going a little bit cross-eyed watching my green screen, trying to move all my files to an external hard drive. Crunch sounds like a break. Well, I mean, she didn't say it was like a break. She's like, it just looks like it was crunched. The knuckles were crunched. So I'll have to wait. I think once the swelling goes down, crunch is not a good medical term. I didn't think so either, but I'm so bad with science. I'm like, just explain it to me like I'm 5. It's fine. Crunched. Yeah, so they're crunched. But it's these two fingers on this side, the knuckles are crunched. These ones are just banged up. Luckily, I didn't break any here. This is where I was worried. I thought I had some fractures here, but nope. She said these are fine, but I've got some crunched knuckles. Smushed. Oh my gosh. Yeah, it's not called that at first. Yeah, a compression fracture. Okay, but was your laptop okay? No, it's not. My laptop is green. It's all green. Like maybe, luckily your cuff it does. Yeah, everybody, you'll be seeing this shirt for the next few lives. It's the biggest one I have. I was just glad that I was able to get my rings on tonight. That was a good sign. Hit the wrong knuckles. Yeah. I'm just, it could have been a lot worse, everybody. So read your side effects for medication, people, okay? Make sure you understand and then clear your area. Oh my gosh. Oh, it did. My laptop did have a crunch involved. I'll show you a little piece. Here's a little piece of my laptop. Oh, my poor laptop. Oh, I feel so sad. I feel really sad about it, but that's all right. Bubble wrap yourself. I know. I need to. I know. This piece came off. I'm like, I hope that's not important. It does look like it's connected to anything. Oh my gosh. Yeah, it could. I suppose it could be. I mean, I'm not really a punchy person. Yep. Sorry. Showing you my parts of my poor broken laptop. Oh my gosh. Yes, I need the boop shroom. I'll have to bring him out again. I know for sure. Oh my gosh. Yes. Yeah, it wasn't the best. It wasn't the best. Yeah, my earrings came out. I have to stop taking this one medication. Although my concern is that she said there's actually 2 medications. And so she's like, let's stop this one and then let me know if anything happens in a week. And so that's a little bit nerve-wracking, but oh my goodness. Yes. Well, actually, I had my nails taken off when they did the x-rays. So I did put some fresh ones on here. So yep. It's healing just great. I'm doing just fine. So Nope. The husband's okay. He's fine. Nope, he's fine. Oh my gosh. Oh my goodness. So, well, with that, everybody, as always, it's been fun to hang out, and I appreciate the time that you took to come and hang out with me. Yes. Oh, thank you. Yes, I've got a fun shape for tonight. So I will be back again this week. Now, I'm planning to come tomorrow. We will see, but tomorrow and then Wednesday I'll be on YouTube. So as far as what we'll review, we'll see. I've got several things I'd like to go through with everybody, so it'll be fun. But yep, I'll call it a night for tonight, everybody. Thank you for coming and hanging out. The Michigan indictments, I do, and I need to put them up on my Tube of You channel. So I will do that very, very soon. So you make my day recently. Oh, Sheila, that's so sweet of you. Yes, yes. Have a great night, everybody. I will be back again as soon as possible. And I wish you all a great night. Sweet dreams. Yes, I'll be very careful. And thank you all, moderators. Thank you. You are all amazing. I'm grateful for your time. I will see you all very soon. Have a great night.